It's recording.
All right, thank you so much. Welcome, everyone. This is our Indigent Defense Commission meeting, January 18th. It is now 2:16. We've just been waiting for people to join in from all over the place, including the Capitol. And we're going to get started. We don't have quite our quorum of commissioners to take care of minutes, but everyone can just have another chance to look at them, and we'll take care of that next time. Open and public meetings training, we've probably all had plenty of that. I get 3 or 4 a year, so we can't secretly meet together, and we don't try. It's hard enough to get together purposefully, but that'll be great, and we'll certainly have that when Sheila's with us, or however it works out. So let's just jump to the legislative discussion, and Matt and Adam can give us some updates.
All right, and what we wanted to focus on, of course, it seems like every year there are 100 more bills filed than the year prior to, but what we wanted to focus on are bills that have either been filed or that will be filed soon that directly affect IDC and the work that we do. One that would be a pretty major add to our responsibilities here is going to be filed pretty soon here. And so I don't know how many of you are familiar with the Aggravated Murder Indigent Defense Fund. But what that is that is a fund that a county can contribute to. And in the event that there is a death penalty case filed in that county, participating counties can draw from that fund in order to be able to hire defense attorneys to do the work, pay for investigators, social workers, and experts. The fund has a formula that takes into account the tax base for the county as to what their share of the contribution would be. This fund is operated, or at least it's overseen by a separate board that's called the Indigent Defense Fund, which is very confusing for a lot of people. We get calls all the time asking about it. That is a volunteer board that is made up of some county commissioners, some prosecuting attorneys, and some defense attorneys. That fund, or that board, primarily just administers the fund. They don't really do any kind of direct oversight of the work that's being done. I don't believe that they handle any kind of issues with client complaints or anything like that. The chair of that board approached me late last year, wanting some help making some technical changes to their statute. And that led to a bigger conversation about IDC taking over the management of that fund. And with that, actually doing some management of the attorneys who are doing that work. And so I know this was something that had been previously discussed, maybe back in 2019, but then there were some obstacles to that happening, and so it didn't go anywhere. But we had a very candid conversation, the chair of that board and I, and he took one of the conditions basically would be that other board, if we take everything over, that other board would need to be dissolved, basically, so that we wouldn't have a competing board trying to make decisions when we already have a very robust and active board here at the IDC. Also, it was problematic with them having prosecuting attorneys as part of their board. It's one of our core principles is that the defense is independent of the judiciary and the prosecution. We don't want prosecutors making decisions as to the hiring and firing of defense attorneys, or whether those defense attorneys have access to investigators or experts or the like. And so he took that back to his board as one of the conditions of this happening, and they agreed to it. So that is something that would be moving forward. There would be a modest fiscal note attached to that so that we would be able to hire somebody part-time to be able to do the actual management of that fund, because we are a very small staff and we're pretty much running at capacity. So if we were to take that on, there would need to be some funding attached to that. So Senator Weiler, it's going to be sponsoring that. They're working on the finishing touches before that's made public, but that is something that I think makes a lot of sense, having that function brought in to the IDC's duties and responsibilities, and I think it'll make sense to our the counties who participate, so that they know if they have any questions about anything defense related, this is the place to come. So that is the piece that I wanted to talk to you about, and if anybody has any questions or concerns, I'm happy to take any questions.
It's great news, because the board that managed it didn't have any expertise in criminal defense at all.
Hmm. Yeah, wow. And there has been confusion about difference between those two things, so that's great to just do it better and put it into one. So it's probably not a numbered bill yet?
Not yet. I should be getting the final draft to review myself any day now, and then it is, you can see the requested bills, and they'll have a kind of a generic title on there. There's one that's Indigent Defense Services, so that's the one that
That's
I
the one.
got a bill file open on.
Any idea of the volume of funds that they deal with on a year, in a year?
They have, well, I understand that they have a couple million in reserves currently. As far as the flow in and out, I think that probably varies from year to year, but from what I understand, they keep that at a certain level, and we wouldn't be changing any of the details as far as the requirements for counties to contribute. Again, the major thing would be the dissolution of the current board, moving that over, and I believe state finance, Department of Finance is where that's housed. Those funds would be housed within the IDC instead, and then we would have the management piece that would be new to that.
Yeah,
It's
great.
really important program for counties.
Yeah.
Yeah, it's really hard on small counties, which is often where the murders happen.
Yeah, I know Davis County is part of that too. So yeah.
Well, I think Utah County is exploring making that transition as well. So
Oh,
that might be a big addition there.
yeah. Wow. Yeah, that's a great update. Thank you.
Sure. I'm going to pitch it to Adam to talk about any child welfare or juvenile court issues.
Sure. As is normal, there's quite a few bills dealing with juvenile justice issues, and there's quite a number this year too, 5 or so far, dealing with child welfare. But consistent with what Matt mentioned, I'll just focus on a couple that really are relevant to us. The first one is one that we initiated. It's HB 199, and it changes definitions of something in the juvenile code called sibling at risk. And it's related to child welfare placement and removal. The language of the bill, or the language of the current law, we believe is overbroad and unclear. And so we're trying to narrow the scope of that so it becomes less so. There will be opposition to it, but it's something we push forward. It came partly through our appellate division too, by a request to change and narrow the definition of a child who is a sibling at risk of another abused or neglected child. And as it turns out, after we initiated that bill with Representative Watkins, we're now involved in an appeal out of a second district juvenile court case that is challenging that statute as being overbroad. So it's got two different facets to it. We'll carry forward the support for this bill and the advocacy for this bill, and we'll assume we'll succeed at the appellate level too. That is one bill you can take a look at. If people have questions, glad to answer them here or in another forum. The other one that's relevant because it came up last year and we took a strong position against it is HB 198, which tries to modify the definition of a really crucial term in child welfare. The term is strictly necessary. It deals with whether the court needs to find that it is strictly necessary for the court to terminate parental rights in order to terminate parental rights. There have been a lot of cases that deal with that, a lot of cases that are trying to define it, or I'm sorry, apply it. And in fact, that issue is before the Utah Supreme Court right now, and we are a party to that case. IADD is a party to that case. So we're opposing any change to the current language, partly because it doesn't clarify anything and it doesn't make it easier for people to understand. It is a term that juvenile court judges are having some difficulty with applying or understanding consistently, but this change to the definition does not help. Same language that came up last year that we opposed, and that was defeated. It actually didn't get to a committee in the Senate. So we'll push for the same outcome this year. I will leave it at that. Pam, I texted you if you'd like to touch base on any of the really crucial juvenile justice bills. I know you're working on quite a few of them. That would be great. But I'm just keeping to those that are directly relevant to our office and our work.
The two juvenile focused ones, I mean, I think there's a bunch of bills that
Right.
increase penalties and have an impact in general that I'm really worried about. Like we just discussed one at the Sentencing Commission today, which is SB 16, or no, HB 16. But the two strictly juvenile focused bills is Senator Pitcher's SB 88, which is like a bill that she's running for myself and Brett. Well, myself, but like, you know what I mean when I say that. Anyway, it clarifies that you can't use jail as an alternative to detention. It clarifies that the age of collecting DNA is triggered at 14, not at 13, and adjudication. And then it also clarifies that you can't collect DNA on a plea in abeyance. In juvenile court right now, there's mixed decisions from judges about that. But like my understanding is they don't collect DNA on plea in abeyances in adult court, but we are in juvenile court. And then it creates a way for Brett to like be able to hold on to money that young people collect or earn while they're in secure care, and then they can have it like, because otherwise JJYS just can't hold money for people. So that one's just, and that one's been supported by both CCJJ and the Sentencing Commission. And Senator Pitcher's bill did make it out of judiciary yesterday with unanimous support. So that one's going. And then there's another bill that's Representative Judkins that felt like is kind of a cleanup bill to our juvenile interrogation bill. And the big thing that it's addressing, the major thing that it's fixing is making it so that a parent can be present by video as well as in person, so that like law enforcement isn't waiting for a parent to drive from one location to another, which is fine. It does have some language in there about what is the remedy for when the statute is violated, and I'm not thrilled with it. It's also could be a lot worse than it is. It's a problem because we had, anyway, so that bill's out there, and it sets a presumption for exclusion, and then it gives it like, it makes it a rebuttable presumption for the prosecutor to overcome exclusion as the remedy. Or at least that's what I hope it does.
Sorry. Is the Miranda hotline bill going to go forward?
No, I've asked her to pull that just because I feel like it needs a lot more upfront work, like with law enforcement, and then also building capacity for the fiscal note for it.
Right.
So I just don't think it's ready to go yet.
Good. I'm glad that you solidified that. That's a good choice. Okay, that's all I have.
Great to both of you for bringing those. The Judkins one, then I guess you don't love it, you don't hate it, you're just kind of watching it.
Well, it's a it's a good, she's worked really hard to like help us with it. What happened is we passed this legislation that says that if a parent isn't there, that you can't even get to reading the child their Miranda rights. And what happened is we had some decision, like we had a case where the officer didn't comply with the statute, but the judge ruled that although they didn't comply with the statute, that remedy wasn't the exclusion, and they applied like basically the factors. Is it the Leon case? That's a federal case that does something similar to that. But that applies really to search and seizure questions. And so it's like, did the officer have like a nefarious intent when they did something? And I really feel like when you're talking about Miranda, that it's not so much the intent of the officer that's the issue. It's the issue is what was the understanding of the person being interrogated. And so anyway, but there was like pushback on like whether or not like, is there the remedy exclusion? And we have a rule of juvenile procedure that says, that is titled admissibility of child statements. And then the next sentence says must comply with statute 80-6-206. But we've had judges rule that that doesn't mean the remedy is exclusion. So then we tried to fix it through the rules committee, and the Supreme Court said, no, we'd rather have it play out through case law. And so then we had to try and fix it through statute, just because I think the problem is it'll take a long time for it to play out through case law. And we've got like decisions all over the map, all over the state on it. So it's an effort to try and kind of clarify some of that. I do think that like the remedy is exclusion. I think that's my frustration with it, is it's very clear to me that the remedy is exclusion. But I think that we've tried to curtail that situation as best we can by creating this presumption. But it also begs the question of, and this is an important part for like us, if we're interested in the Miranda bill, is like Representative Gwen, who is a law enforcement officer who's been working with Representative Judkins on that bill. In fact, adding the presence of a parent by video is to accommodate a request from Representative Gwen. And I think that like we should be approaching him about like really the way to make this the best protection is to just make sure that it's an attorney present. And I think that that alleviates a lot of confusion for law enforcement as well.
Thank you.
And that's what Adam was referring to as our Miranda bill. What we would ultimately like to do is create, like Washington State has a Miranda hotline, where if law enforcement is going to interrogate someone as like they're in a custodial setting, then they can call this 1-800 number, and the youth can immediately talk to an attorney and be advised about whether or not they should engage in the interrogation. And then the officer isn't jumping through the hoops of making sure that a parent is there, offering child like specific Miranda and all these other things. Instead, it would be like a lot easier and faster, I think, for law enforcement as well.
Thank you. Any other questions that people have? Okay. All right. Well, if that's the all of it for the legislative discussion today. I mean, these are what, today's the third day of the session, so there might be more, and no doubt you're still, all of you, much busier with everything going on. But I guess that'll take care of number 4 on the agenda. You know, I didn't ever really say who was on the call. I'll just do that really fast, or in the meeting for all the open and public meeting stuff. But Katrina Adair staff, Josh Buhay staff, Adam Troop staff, John Quorum commissioner, Michael Zimmerman commissioner, Matt Braza, the executive director, Casey Hopes commissioner, Deborah Nelson staff, Margaret Lindsay commissioner, Ryan Luce commissioner, Pam Vickery commissioner, Mary Corporon commissioner, Leslie Howitt staff, and Lisa Shepherd. Lisa, you represent someone or Salt Lake somehow, is that right?
Lisa's on our Utah County.
Yes, I work with Commissioner from Utah County. The IDC is in my portfolio.
Oh, and which commissioner from Utah County?
Tom Sakovic.
Yeah.
Oh, wonderful. Okay, great. Yeah, thank you for being with us. Okay, so she's not a voting member, but yep, definitely representing Utah County for another county commissioner. All right, and then I'm Lorraine Kamalu, serving as chair right now. Okay, well, we're moving right along. So the next thing on the agenda, select the next commission meeting date. And I was just gonna pull up the calendar. Like, I think Katrina, you gave us monthly dates, right? But then sometimes we adjust those a little bit. Do you wanna tee that question up?
Lorraine, we do have a quorum now if you want to go back to the meeting
Yeah.
minutes.
We will do that. Thank you. I was thinking the same thing. But do you want to bring up whatever the question is about our next meeting date? Is it on the calendar already?
Looks like it's on the 15th of February.
Thank you. Yeah, that's probably the regularly scheduled time, right? The third
Yes.
Thursday.
Although historically, well, historically, over the past few years, we have skipped the February meeting because people are so caught up in the session by
Yeah.
that point. So maybe we can just keep it as a placeholder, but then in the weeks before that, we can, I'll come to you, Chair Kamalu, and see if we need to keep that on or not.
Yeah, you're right. I do very much remember a lot of times we have not had the February meeting. And I think that works great, Matt. If you just want to see whether we really end up needing it, and if not in advance, we can tell people to free up that time.
Right.
I like that. Okay, great. And so let's go back then to that first item, which was the approval of the minutes. Katrina sends those to me and Matt in advance, so I know I've looked at them, but if anyone else has been able to take a look at those, I'm happy to take a motion. That would have been for the last meeting, and I think we did meet in December, right? I don't have it up in front of me.
There were 3 meeting minutes, one for the March meeting, an April meeting, and then December.
Oh, all 3. Thank you.
I'll move we approve those minutes.
All right, thank you, Ryan.
I'll second that.
And that was Casey. All right, I have a motion and a second. All in favor to approve all of those minutes, please say aye.
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 And is there anyone who is opposed? All right, that's unanimous. Thank you. Good minutes. They've been always so good in this commission. Okay, so I think, let's see, we don't have our open and public meetings training, I guess, for today, Matt.
I'm sorry, everybody. I reached out to the AG who was going to provide that. I know she has some ongoing health issues, so that might have played a part. So we'll have to do that at our next committee meeting, commission meeting. I hope you can wait that long. I know it was a lot of anticipation for it today, but it'll give us something to look forward to for our next meeting.
Yeah. Casey and I already had a discussion about that as someone in the legislature is wanting to tweak it, right, Casey? So we're, I think pretty much all of the county commissioners were like, no, don't tweak that.
Well, I know CCJJ just had theirs recently for that commission, so I know that Pam, you were probably there for that, and so we are pretty well acquainted, but it is that statute that says we have to do it annually.
Yeah. Yeah. Okay. Very good. Okay. Is there any other business or any public comment for this meeting? Okay. Seeing none. We are at the end of the agenda. And thank you so much, everyone. Thanks for making time, and especially at such a busy time.
Thanks for being here.
Everyone's enjoying the winter and the snow and especially the blue skies today. Yay for moisture, right?
Oh,
All right. Thank you so much. Appreciate you all.
thank you.
Hey,
Yeah.
Commissioner Holtz and Commissioner Kamalu?
Yeah.
We were wondering if you could just stay on for a little bit afterwards. We had a couple of questions that